call the meeting 3 of the Compliance Audit Committee to order. Welcome, everyone. Today's meeting is held with committee members, city staff, and parties participating both by video conference and in person at City Hall in Committee Room 2. City Hall is open to the public, and anyone is welcome to attend the meeting. The public may continue to participate electronically by video conference. This meeting is also being live streamed online at www.youtube.com/Toronto City Council Live. I ask everyone for their patience with any delays and technical issues. I'd like to ask everyone to please keep your microphones on mute unless you are speaking. Members, please ensure that your video is turned on at all times. As part of each agenda item, I will ask members to raise their hand or unmute their mic if they wish to ask questions or to speak. When voting, members, please raise your hand in front of your camera to indicate your vote. Although we are in different locations and meeting remotely today, the Compliance Audit Committee acknowledges the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Members, are there any declarations of interest under the Municipal Conflict of Interest Act? If you have an interest, please raise your hand or unmute your mic to let me know. All right, I do not see any expressions of declarations of interest. May I have a motion to confirm the minutes of the meeting on July 13th, 2023? Thank you. We have the motion, and please raise your hand. All in favor? Yes, Mr. Faraji made the motion. Sorry about that, folks. And all in favor, raise your hands. All right, the motion carries. I'll now outline the procedure and format of the committee meeting. We have 4 items on the agenda, which are 4 compliance audit applications. Before we consider the applications, I'll outline the procedure and format for considering them. The 4 applications to consider today are the following. Item EA 3.1, Compliance Audit Application by Kevin Wiener for the election campaign finances of Sandeep Shrivastava. Item EA 3.2, Compliance Audit Application by Kevin Wiener for the election campaign finances of Marco Valle. Item EA 3.3, Compliance Audit Application by Kevin Wiener for the election campaign finances of Lorenzo Berardinetti. And item EA 3.4, Compliance Audit Application by Kevin Wiener for the election campaign finances of Antonois Mantis. An applicant, candidate, or their agent who has registered with the clerk may speak to these items. The applicant and candidate will be given sufficient time to address the application, although we would ask that you really stick to the facts of the application rather than providing sort of broader background if possible. For each application, we'll hear from speakers in this order: the applicant or their agent, followed by the candidate or their agent. If you wish to speak and have not already registered your intention, please email the clerk staff now at complianceaudit, it's one word, @toronto.ca. Speakers are asked to confine their comments to the compliance audit application item being considered. After each speaker, compliance audit members will have an opportunity to ask speakers questions. Members may ask questions of city officials to obtain information relating to the matter under discussion. If the committee decides it needs to meet in closed session to deliberate in private, I will move a motion to close the meeting, at which point members of the public and media will be moved into the WebEx lobby and readmitted once the committee resumes its public session. We may do this multiple times this meeting, as we will consider each application separately. For each item, after we have completed our closed session deliberation, we'll resume in public, and the committee will make its decision at that time. Are there any preliminary motions from the members? All right, seeing none, I would propose that we now proceed with our first application. So EA 3.1 compliance audit application by Kevin Weiner for the election campaign finances of Sandeep Srivastava. Are there any preliminary requests from the parties? Okay. The applicant and candidate will now be given the opportunity to speak. They will each be given sufficient time to address the application. Please confine your remarks to the compliance audit application before us. I believe we do have Kevin Weiner with us today, and if so, if you could please commence your presentation.
Thank you, Madam Chair, and for you members of the committee. This is a compliance audit application with respect to the mayoral campaign of Mr. Srivastava. Mr. Srivastava did file a financial statement. That financial statement indicated that he had revenues of $0 and expenses of $4,584.97. My submission is based on that fact that there were zero revenues, and based on the fact that there is no indication of any bank charges. There are reasonable grounds to believe that Mr. Srivastava, one, did not open a campaign bank account as required under the Municipal Elections Act, and secondly, given that these expenses had to be paid by someone and that Mr. Srivastava did not extend his campaign period, that the financial statement as filed is not accurate, as it does not indicate where the revenues to pay those expenses came from, whether it was a loan or donation from someone or a donation from the candidates, and therefore a compliance audit is warranted to determine exactly how these expenses were paid for and whether there were any breaches of the Municipal Elections Act. I did get a phone call last week from Mr. Srivastava. I attempted to explain to him that I had just initiated the process and that he should be coming to this meeting. I see that he has, so I'm sure can provide more light to the committee. My understanding from what he told me was basically that these expenses were put on his credit card, that he didn't have the money to actually pay them, and that he did not open a campaign bank account prior to incurring those expenses. So, I mean, I'm sympathetic to the situation, but in my submission, the Municipal Elections Act doesn't allow for someone to use a credit card to personally finance campaign expenses. You have to take a loan, which you can guarantee into the campaign account, but you can't take a loan outside of the campaign and use that to fund campaign expenses if that was indeed how those expenses were funded. But as I've said previously, at this juncture, the role of the Compliance Audit Committee is not to determine whether or not enforcement should take place. It's simply to determine whether there is enough grounds to believe that a violation of the Act took place so as to initiate a fact-finding process through a compliance audit, which the Court of Appeal of Ontario has made clear is not an adversarial process at that point in time, which is why it doesn't give rise to rights against self-incrimination. It's just a fact-finding process, which comes back to the committee and allows the committee with full facts to, at that point in time, exercise its discretion on whether or not to commence legal proceedings. So my submission today, as it has been previously, is at this point in time, while there is some limited discretion before the committee on whether or not to commence an audit, the only time that the courts have upheld such a discretion was where there was a corrected financial statement filed, where it was very clear what the violation was, and it was very clear that the violation should not give rise to any enforcement, and that a compliance audit would not shed any new light on any information. And in this case, again, there is no, the candidate, I mean, he may have an explanation, but he hasn't filed before this committee, for example, a corrected statement of what should be the financial statement. So in the absence of falling within those very limited circumstances where the courts have found a discretion to not order a compliance audit where there are reasonable grounds to believe that there's a violation. In my submission, that audit should be ordered. And of course, when it comes back, there's no requirement the committee commence legal proceedings. The audit's just that fact-finding process. Subject to any questions from you, Madam Chair, members of the committee, those are my submissions.
Thank you, Mr. Weiner. Do any members of the committee have questions for the applicant?
I don't.
Okay, thank you. Would Mr. Shrivastava or his agent please begin?
Hi, this is Sandesh Srivastava. Can you guys hear me?
Yes, we can. Please go ahead.
When I filed my nomination, I talked to the election Toronto, and they told me that if I'm getting donation or contribution, or if I'm claiming any like rebate, then I need bank account. So I was trying to get donations, and I was unable to get any donations. So that was the main reason I didn't open an account. And all the rules and regulations, you guys talking about all those details, I got it from the compliance audit committee, like full details about all these finance stuff. I didn't know all those things if required or not. I didn't have clear information about those things. So that's the main reason these things happen. And I don't know what to do, because when I filed the financial statement, I filled all those expenses that occurred. I used my credit card to make the payment. And some of them are paid on time, some of them not paid because the interest occurred. So due to like COVID, inflation, all these, people not donating, they didn't donate me because they were complaining about high rise of expense, lots of issues they're having due to COVID. So they were not donating me. I was talking to people. That was the main reason. So I was stuck in this election without donation. So I used my credit card.
Okay.
So that is the main reason these things happen. I did it properly because I didn't have proper information from Election Toronto for that. Like the email you guys send me PDF file, like full details about the rules and regulations. So that thing I'm talking about.
Okay, thank you. So I do have a question for you. And you indicated that you did not know that what the requirements were around opening a bank account and taking out a loan. How did you become aware that a financial statement needed to be filed?
I talked to the Election Toronto. They told me to file the financial statement. I don't need auditing report because there's no claim dealing with donation or any claims. So they said just fill all the details, and I filled all the details and sent them, and they approved it, and they signed it back. They emailed me back.
Okay, thank you. Do any members?
And I know I made a mistake. I'm not supposed to do that. Like I notice now that I'm not supposed to do that. So first time I'm running for a mayor, right? So lots of things I learned from this election, and things happen. That's the only thing. I didn't do that. I didn't open the account, and loan. People don't give a loan for election. I don't know if people unless you have good relationship with the bankers, then of course you can get. But I don't have any good relations with the banks for the loan.
All right. Thank you.
You know what I'm talking about, right? Because lots of issues right now, right? Dealing with loan, interest rate is very high, and all those things.
Okay. I believe Member D'Souza has a question for you.
Yeah. Mr. Srivastava, ignorance of law is not an excuse. Elections website has got all candidate resources. It has got a candidate guide. There are videos. There are information sessions were conducted for candidates. So that's certainly not an excuse. All the details, whatever you said, you're not informed, they were there on the website. They're still there.
I understand that, but the confusion was about the opening the account and donations, contribution, those things. I was a little bit confused about that, claiming like donation, like rebate stuff, right? So that thing was not clear. So that was thing happened to me. If I knew that it's mandatory to open an account, no matter what, then I could have opened that account, and the file you guys send me, if you guys have sent me that, like if they provided me that file, like when I filed for a nomination, I could have go through that file, that rules and regulations you guys discussing about election account.
Candidates guide.
I understand what you're telling me, that everything on the website, but the thing is, I didn't go through the whole website. I didn't do research on the website. That's my mistake. I know, and I apologize for that.
Thank you.
Thank you. Any other questions?
So my question is, so let's say you running for the election. So, and what is the process? I just want to clarify properly by the law I'm talking about. What is the process when you run, when you get the nomination, and what is the process? What is the steps? What is important to watch out, and what kind of things has to be needed to be done? So these things won't happen again. That's the thing I'm saying.
Well, as Member D'Souza indicated, there are very rich resources on the website. There's quite a bit of information there, both videos, information sessions, as well as printed material, and there is the legislation as well. The legislation is technical, it's detailed, but there are many, many resources available. We're not here to go through sort of the process. What we're looking at today is whether there has been a violation of the legislation.
So what should I do with this situation? What should I do to clear my this issue?
Well, at this point, we have heard the submissions, both from the applicant and from yourself. And I'm going to recommend that the committee go into a closed session. We will deliberate and we will come back with our decision.
Okay. Yeah, I apologize. This thing happened, because there was not clear communication between me and Election Toronto. So this is my recommendation, right? The file you guys send me, right? They should provide that whole file, right? Dealing with the rules and regulations when the people get nominated. So this way they'll know, like the full details. They go through all the details, rules and regulations. So it will help us, everybody,
Okay. Well, we'll take that back. I would like to bring forward a motion at this time to go into closed session. Yes. So all those in favor, members, please raise your hand. Thank you. The motion carries. I'll ask the clerk to temporarily close the meeting to members of the public and to only provide access to committee members and appropriate staff for the closed session portion of this meeting. In addition, the YouTube live stream will be suspended until the closed session is over. Members, I'd also remind you to arrange your surroundings so that no other person observes any part of the closed session discussion. Thank you, everyone, for your patience. We have completed our closed session deliberations. I do have a motion that we will be sharing, and the decision, and that will be put up on the screen. I'm not going to read the full decision, but I do want to emphasize several paragraphs. So first off, the motion is that the Compliance Audit Committee reject the application for a compliance audit of the election campaign finances of Sandeep Shrivastava. And if we could scroll down to paragraph 6, please. Thank you. I do want to read this out. The respondent indicated that he was not aware of the obligation to comply with certain financial requirements. It is the individual's duty to understand their legal requirements when they become a candidate for election, and there are many resources available to assist. Ignorance of the rules is not a compelling reason to avoid compliance of the legislative regime. The committee does understand that the respondent has recognized that mistakes were made, and the committee is satisfied that these were not intentional. May I have a motion, please, for members to vote on, or rather, can I ask members to vote on this? All in favor? All right, thank you. The motion carries. Thank you to the applicant and the candidate. We're now going to move on. Our next item is EA 3.2, Compliance Audit Application by Kevin Weiner for the election campaign finances of Marco Valley. Are there any preliminary requests from the parties? Okay, I don't see any. The applicant and the candidate will now be given the opportunity to speak. They'll each be given sufficient time to address the application. Please confine your remarks to the compliance audit application before us. Mr. Weiner, do you wish to begin?
Yes, thank you, Madam Chair. This is an application for a compliance audit for Mr. Marco Valley. Mr. Valley was a candidate for councillor in Ward 3. According to the city clerk's office, he is in default of his obligations to file a required initial financial statement, and therefore has been automatically barred from being a candidate for election until after the 2020-26 election. I did conduct some research, which is attached to my application, which indicates that Mr. Valley did incur what appears to be somewhat significant campaign expenses, including purchasing billboard space, as well as literature and a relatively slick-looking website. So my submission is, as I said last week with another candidate, this is not a case of a candidate who did not run any campaign, did not incur any expenses, and just forgot to file a financial statement. There clearly were significant expenses incurred here. We don't know how much was spent. We don't know how much was donated. We don't know who donated. We don't know if anyone donated over $100 or how many people there were. We don't know if anyone donated over the cap. We don't know if the spending was over the cap. The courts have described the requirement to file a financial statement as fundamental because it's what gives rise to any ability to review finances and make initial determinations about whether more investigation is warranted. I see from the list of attendees, Mr. Valley appears to be here, but from what I can tell, no documents were filed before the committee on this agenda item. There has been no attempt to, for example, file there's no procedure to actually file a financial statement before the committee. A candidate could certainly say, provide a statement to the committee saying, if I were permitted to file a statement with the clerk's office, this is what would be in my statement. So the reality is we don't have any information about this campaign. And yes, while it's true, anyone who doesn't file a financial statement is barred from office, that may or may not be a compelling penalty for non-compliance with respect to maintaining confidence in elections. And it's impossible for the committee to know whether that's a sufficient penalty in the absence of a compliance audit that actually tells the committee how much money was spent on this campaign, where did it come from, and were there any violations other than just failing to file a financial statement. So as I've said repeatedly, this process is just to start a fact-finding process. It's just to have an auditor take a look at the campaign to determine whether there were any violations. It's very clear that there's reasonable grounds to believe that a violation occurred. The Municipal Elections Act is very clear that the automatic disqualification does not in any way limit an applicant's right to come before this committee or this committee's right to initiate an audit. And in the absence of the information that would be in a financial statement in my submission, it is appropriate, given expenses have clearly been incurred and what appear to be significant expenses have been incurred, to order a compliance audit. And then once the committee has information from a compliance audit about what happened in this campaign, at that point it would be in a position to determine whether additional legal action is appropriate or whether the automatic disqualification is sufficient consequence for everything that happened in this campaign. Subject to any questions, Madam Chair and members of the committee, those are my submissions.
Thank you, Mr. Wiener. Do any members have any questions of the applicant? Okay. Mr. Valley, do you have some submissions that you wish to make? Just trying to connect with Mr. Valley. We are still trying to reach him. Bear with us, please. Sorry, we're having difficulty reaching the candidates, or the candidate. Just bear with us for a moment, please. All right, thank you for your patience. We seem to have technological difficulties reaching Mr. Valet, so we're going to hold this item down. And with the applicant's indulgence.
Hello, sorry.
Oh, do we have somebody?
Hi, yes, it's Mark Valley. I
Oh.
have no idea what happened there. I've been here the whole time staring at a black screen. I completely apologize.
All right, well, we were just about to move on, so perfect timing. But you were able to hear the applicant's submissions, correct?
No, ma'am, I apologize. I've literally been listening to nothing, and I just heard that you were about to move on from me. That's the first thing I've heard since you closed for the closed session.
Oh, right, so you did not hear the applicant's submissions with regard to this application?
No, ma'am, I apologize. I guess we can continue. I don't know how this works. I've never done this before.
Okay, just a moment. All right, sorry, I've just received guidance here. If I could ask the applicant to make, a very, very brief summary of your submission, just a line or two. The candidate does have the application available, and there is a summary there. However, just in the interest of, giving him a little bit more color, if you wouldn't mind simply high-level summary, and then we can hear from the respondent. Thank you.
Sure, thank you, Madam Chair. The high-level summary is given Mr. Valley is in default. There clearly are reasonable grounds to believe that he committed a violation of the Municipal Elections Act. So really the only question before the committee is the exercise of discretion on whether or not to order a compliance audit, given there are automatic penalties. And my submission is, in the absence of a detailed financial return being before this committee, there is insufficient evidence before the committee about what this campaign did with respect to how much money it raised, who it raised it from, whether there were donors over $100, how much it spent, etc. There's just not enough information for this committee to be able to meaningfully exercise discretion over whether or not to commence legal action. And so given this is just a fact-finding process and to maintain public confidence in elections, it would be appropriate to order a compliance audit so an auditor can make their own determination as to the state of Mr. Valley's finances and come back, and then the committee can decide whether the automatic penalty by itself is appropriate or whether it's appropriate for there to be an additional legal action.
Thank you, Mr. Wiener. Appreciate it. Mr. Valley, do you wish to respond?
Yes, ma'am.
Please go ahead.
Okay. First off, I'd like to apologize to Mr. Wiener. I don't know what happened, but I apologize for having to make you repeat yourself and to the committee for this. But in an effort to respond, I don't have an excuse. I had my father suffered a catastrophic accident last year, which left him as a quadriplegic. And at the time of just like during the election and just after, it was when his care was moving from Alberta to here, and then from here in a facility to home. And so I was assisting in all of that. And not an excuse. I have my finances. I have like my Excel sheets that have everything. I can submit it. I'm more than happy to do a compliance audit or to submit it once audit. I don't know how to fix this, ma'am, but I do have everything in order. I completely respect and understand and appreciate Mr. Wiener's position on this, and because I should have submitted. I had extenuating personal circumstances that delayed me. That is all, ma'am. And I'm hoping that by submission I can correct this, but I'm not going to tell you that that's the answer because I don't actually know that, ma'am.
Okay, thank you. Unfortunately, you've missed the deadline to be able to submit. Did you at any point reach out to the City of Toronto to request an extension for the filing date?
No, ma'am, I did not. I did have a contributor that I've since refunded, but I had a contributor that I didn't believe was residing in Canada, which delayed me. And then that just tracking that person down, that just delayed me in doing it. And then with life, I just didn't circle back. Again, 100% my fault. But no, I did not reach out while I was tracking down that one donation.
Okay. Members, do you have any questions of Mr. Valley? Go ahead.
Did you open a bank account?
Pardon, sir, if I understood you correctly, you asked if I opened a bank account?
Yes. Did you open a bank account?
Yes, sir, I did. On the first day when I filed, I told the clerk that I had no idea what to do next, and they recommended I opened a bank account. So that was the first thing I did.
Mm-hmm. What are your total expenses?
Sir, give me 1 second. Let me just change over. Total.
Expenses.
My total expenses, everything, taxes and everything in, was $3,983.91, sir.
What about the donations? How much you received? What is the revenue?
Do you want me to include myself in that, sir?
Yes, including yours.
Including my own contributions and my spouse's contributions, sir, we hit that exact same number to the penny. I received less contributions than expenses, so I covered the difference, myself and my wife, sir.
Okay. Thank you.
Any other questions? Okay. Thank you. May I have a motion to go into closed session, please? Oh, actually, there it is. And the motion is that the Compliance Audit Committee recesses public session to meet in closed session to deliberate in private on item EA 3.2 compliance audit application by Kevin Wiener for the election campaign finances of Marco Valley and to receive advice that is subject to solicitor-client privilege. Members, can you vote, please? Raise your hand if you're in favor. Thank you. And at this time, I will ask the clerk to temporarily close the meeting to members of the public and to only provide access to members and appropriate staff for the closed session portion of the meeting. In addition, the YouTube live stream will be suspended until the closed session is over. Members, I would also remind you to arrange your surroundings so that no other person observes any part of the closed session. All right, we are back in public session. Thank you, everybody, for your patience. We have completed our closed session deliberations, and I would now like to read the decision, and we will be sharing the motion. So the motion is that the Compliance Audit Committee reject the application for a compliance audit of the election campaign finances of Marco Valley. Thank you to the applicant and to the candidate for your submissions. At this time, we're going, oh, I apologize. I'd like to vote on that, please. All in favor of the motion, raise your hands, members. Thank you very much. And the motion carries. So at this time, we're going to take a 15-minute recess. It is 11:04 Eastern Standard Time, so if we could come back at 11:20 Eastern Time, please. Thank you very much. May we have a motion for that, please? All in favor? All right, and the motion carries, and we will take a brief recess. Thank you. We're back in session. Thank you. Our next item is item EA 3.3, compliance audit application by Kevin Weiner for the election campaign finances of Lorenzo Berardinetti. Are there any preliminary requests from the parties? All right, seeing none, we will proceed. The applicant and the candidate will now be given the opportunity to speak. They will each be given sufficient time to address the application. Please confine your remarks to the compliance audit application before us. Mr. Weiner, do you wish to make your submission?
I do, Madam Chair. Thank you. Mr. Berardinetti was a candidate for councillor in Ward 20 who is in default of his obligations to file a financial statement. The automatic penalties have already been levied, as with the last application. I've attached evidence to indicate that Mr. Berardinetti did in fact incur at least some expenses. You can see that there is a website which at a minimum would involve some sort of web hosting and domain expenses. At the very bottom on page 7, the last page of my application, you can see that the website design is by myagency.ca, which again indicates that a third-party professional web design firm was hired to design this website, which would be additional expenses. The website itself says I have secured a campaign office at 2279 Kingston Road. So again, that's yet more expenses for a campaign office. I don't have direct evidence as to whether there were signs or literature or things like that. I think it can certainly be inferred if there's a campaign office, there's at least some literature. So I think there are certainly reasonable grounds for this committee to conclude that this campaign incurred expenses and raised money. The second thing I would point out, and I don't believe Mr. Berardinetti is here or has sent anyone, so I'm not sure if there'll be any additional information that the committee gets. As Mr. Berardinetti says in his own website, at page 2 of the website, I believe. Yes. Having 15 years of experience as a city councillor and 15 years of experience as a member of provincial parliament, I am qualified to fight on behalf of my neighbors. I am a lawyer. So, in my, this is not someone where, there's some compelling circumstances why they didn't fully understand what was going on. They didn't know they had an obligation. Mr. Berardinetti was a city councillor for a decade and a half. I believe this was back when terms were 3 years. So he would have gone through 5 elections. Municipal elections, and I think probably 3 or 4 provincial elections. Every single one of those elections would have required some sort of financial requirements, would have required disclosures. If it's a provincial election, you have an official agent. Almost certainly audits would have happened in some of those. As a lawyer, Mr. Berardinetti would have very well an understanding that he needs to file a financial statement and why a financial statement is so important. So I would submit that there's a heightened interest and confidence in the administration of justice and seeing that this committee order an audit and determine what exactly happened in Mr. Berardinetti's campaign. And I'd point out, yes, there's automatic disqualification. And if you have been elected, automatic disqualification is a very strong penalty and a very great reason to file your financial statement. And we saw that with Councillor Karagianis last term, where he was booted out of office because he didn't, or because he filed a financial statement that showed overspending without any requirement to go through the compliance audit process. If you have lost an election, however, and if you're not planning to run in the next election, forfeiture really doesn't mean much. You haven't been elected, so you're not losing anything right away. And if you're not going to run in the next election, as Mr. Berardinetti, I don't believe, had run in a few elections before this cycle, in 2 cycles, you're free to run again. That's part of the reason why, in addition to automatic forfeiture, there is a process for potential prosecution, fines, things of that nature, particularly if something is delivered. And again, we have no information as to whether this was an inadvertent failure to file or whether there was something in this campaign that Mr. Berardinetti didn't want filed and therefore deliberately chose not to file. We have no information about the circumstances behind this failure to file. Now, the committee has cited in its previous 2 decisions a decision of the Superior Court of Justice at Lancaster with the citation 2012 ONSC 5629. And there's a couple things from that case I would like to draw the committee's attention to. First of all, the court makes a citation to the case of Braid and Georgian Bay Township. This is at paragraph 66 of the Superior Court's decision, and I can share a screen because I assume the members of the committee don't have the ability to immediately see that. So, Madam Chair, if I can just get screen sharing.
Yes, go ahead.
And so what we see, so what we see here, paragraph 66, the court cites to Braid, where there's a reference, and Braid isn't uncanny, that there's a dichotomy between strict liability for complete failure to file and a more lenient approach where the document is filed but incorrect in some way. Failure to file leaves the public no ability to examine the expenses of a candidate. Such a failure leaves the interested person with no starting point from which to begin an examination. It strikes at the very heart of the Act's purpose. And that compares it to filing a document that is flawed in some way, which is a different proposition, in which case the language, in which case there has been substantial compliance, because even a flawed statement provides a starting point. Further down, and in this case, just to give some background, there was basically what happened in Lancaster was a bunch of related corporations made donations to some city council candidates. This got out in the news. A member of the public applied for compliance audits. At that point, these candidates decided to give back the money as they realized that they were related companies. But the court found it was very clear all these companies had the same president, the same signing officer, et cetera. Some inquiry was warranted, but nonetheless, the companies gave it back right away. So the court found there was no violation of receiving illegal donations because the only obligation is to give them back right away when you become aware. But the financial statement itself was missing some information of these corporate donations, and the court basically overturned the committee and OCJ findings that this wasn't a violation. The court said this was a violation, that any incorrect financial statement is a violation because there's strict liability. But in this case, it was reasonable not to order a compliance audit. And so you have the grounds of appeal down here. And over here is where the committee says, once the act has been breached, it's about deciding whether an audit is warranted. I point out a couple of things. Down here is sort of the ultimate part of the decision. And first, there was uncontradicted information received by the committee that the omissions were unintentional. And there is not a flicker of further information to be obtained from an audit, and therefore it would have amounted to a speculative expedition and ended up revealing what was already known. Elsewhere, I don't have the exact paragraph right now, but elsewhere with respect to illegal contributions, the court does note that if the illegal contributions had not been returned, then obviously it would be a violation of the act, and an audit would be warranted. In other words, that sort of violation would not warrant the exercise of discretion. So my submission is what can be taken from Lancaster is there are limited circumstances in which it is appropriate not to order a compliance audit. And that is essentially where the violation has been admitted and there's no dispute over what happened in the violation. And again, in Lancaster, the donations have been returned and the committee already knew what should have been on those forms because they knew who the corporations were, they knew who the president was, they knew who the signing officer was. So there was zero information that could come from an audit. Everything was before the committee. And so in those circumstances where it was a very minor violation and where nothing could possibly come from an audit, then okay, they don't order an audit. And I'd submit in this situation, it's a very different situation. For one thing, it's not a erroneous it's not an erroneous filing, it's a total failure to file, which as the court said, strikes the very heart of the act's purpose. That means there's nowhere to even start overviewing what happened. There's no corrected materials that have been provided, as was done in Lancaster, where corrected materials were provided. So the committee was able to see, okay, this is what should have been filed, and there's no dispute as to what should have been in this form. We don't have from Mr. Berardinetti, oh, this is the form I would have filed. And so even though the clerk won't take it, I can still submit it as an communication to this committee, and then it's still a public document, even if it's not with the rest of the filings, but in some ways it's remedied. And this is not a case where, there's agreement between the applicant and the candidate as to exactly what happened in this campaign and what the violations are. My position remains, we have no idea what happened in this campaign. We don't know if there are other violations. I point out that last week, just starting this process caused it to come to light that a candidate appeared to have received anonymous donations, which would not have come to light if this process had not been initiated. So in my submission, unless this committee can confidently say it will not get any information from an audit that would go to its exercise of discretion on whether or not to initiate litigation, an audit is appropriate. And given a failure to file, in my submission, it's not appropriate for the committee to be able to prejudge right now and say the penalty of disqualification is sufficient, because we don't know what happened to this campaign. Now, if the committee gets the audit and finds out what happened to the campaign, and at that point it wants to say, you know what, that penalty was already sufficient, there's no need to commence legal action, that's totally within the discretion of the committee. But in my submission, it's inappropriate without having that information to prejudge whether the penalty is sufficient. This is not a situation like Lancaster where nothing can come from an audit. Very clearly, something can come from an audit, because an auditor will tell us what this campaign spent money on and where it got its money from. And that is information the public should have access to maintain confidence, particularly where the person who failed to file is someone who has been a politician for 30 years and is a member of the Law Society and would very clearly understand his obligations. And I'd submit if this did go to court, those would all be aggravating factors that would be considered by a court in deciding whether any additional penalties should be warranted. So again, subject to any questions, Madam Chair, those are my submissions.
Thank you, Mr. Weiner. Do members of the committee have any questions for the applicant? Nope. Okay. Well, at this time, I'm going to make a motion that, now, I guess before we do that, I just want to make sure that the candidate is not present and, or his agent. No? Okay, I'm going to make a motion that we go into closed session. And the motion is that the Compliance Audit Committee recess its public session to meet in closed session to deliberate in private on item EA 3.3 compliance audit application by Kevin Weiner for the election campaign finances of Lorenzo Berardinetti, and to receive advice that is subject to solicitor-client privilege. May I have a vote? All in favor, members? Thank you. Motion carries. At this time, I'll ask the clerk to temporarily close the meeting to members of the public and to only provide access to members and appropriate staff for the closed session portion of this meeting. In addition, the YouTube live stream will be suspended until the closed session is over. Members, I would also remind you to arrange your surroundings so that no other person observes any part of the closed session.
Thank you, Madam Chair. Hello, everyone. This is the committee administrator from the City Clerk's office. I'm going to read
We are back. We have completed our closed session deliberations, and we will share the motion that we will be making. All right, and the motion reads as follows, that the Compliance Audit Committee grant the application for a compliance audit of the election campaign finances of Lorenzo Berardinetti. I won't read the rest of the decision. It will be posted very shortly, but the applicant made a very persuasive submission, so we thank you for that. And so the motion has been presented. If I could have a vote, please, of the members, and it passes. Thank you. So we're going to move on to our last item at this time. That is item EA 3.4, compliance audit application by Kevin Weiner for the election campaign finances of Antonius Mantis. Are there any preliminary requests from the parties? All right, I don't see any. The applicant and the candidate will now be given the opportunity to speak. They will each be given sufficient time to address the application. Please confine your remarks to the compliance audit application before us. And Mr. Weiner, you're welcome to make your submissions.
Thank you, Madam Chair. Antonius Mantis is a candidate for City Council in Ward 22, and as with a few of the other candidates who have applied for compliance audit, did not file a financial statement. So, I mean, I'd rely on my previous submissions with respect to the fact that I don't believe Mr. Mantis or an agent is before the committee to provide any context. And so, again, we're left with, you know, while it's not the same situation as Mr. Berardinetti, where he's had decades of experience being a counselor, a lawyer, nonetheless, you know, it's stressed multiple times by city staff or anyone who's a candidate, you have to file a financial statement. And, you know, not filing a statement at all is a very different scenario from, you know, not quite knowing how to fill out the statement properly. So I'd submit that in the absence of some evidence to the contrary, you know, even someone without that level of experience should still be filing that statement. And it's still, again, the failure to file a statement, as the courts have said, strikes at the heart of this entire regime. We do have a Toronto Star article that says at minimum, Mr. Mantis was handing out flyers and running some level of campaign in the ward. And this is a situation where certainly some allegations were made in that article that, you know, potentially Mr. Mantis had been a sort of straw candidate put forward by another council candidate potentially to have the same name as the incumbent councillor and create confusion for voters. Now, that's not what this it's, you know, that's not what the decision for the committee is about, whether that's the case. But I think it gives context to the question of whether being barred from running again, in the absence of any information about what's happened in this campaign, can be seen as a sufficient penalty. If you have someone who basically was potentially funded by an outside source, maybe in violation of donation limits, in order to sort of torpedo another candidate's campaign, knowing that they cannot file a financial statement and the only consequence would be that they don't run again, then that's something that in my submission would undermine confidence in the administration of the election system. In the absence of any evidence as to what happened in this campaign, there's at least the potential that a compliance audit will find further violations with respect to how this campaign was funded, given the odd scenario of someone who had their nomination apparently signed by people who don't live there, things like that. There's just in general the whiff of something not quite right about this campaign. And if we had a financial statement, it wouldn't be an issue, but we don't have a financial statement. So again, we have no idea, did Mr. Mantis self-fund his campaign? You know, did he receive a few donations from people who made large donations? In which case, it would be very relevant to the public interest to know who made those donations and whether they had, you know, whether they were affiliated with other candidates, things like that. Did someone donate over the cap? Again, in the absence of any response to this application, we simply don't know. All we know is that this campaign did seem to spend money and then didn't file a financial statement. And as with the last application, by submission, even without the candidate having, you know, a lot of experience as a counselor and as a lawyer, that's still enough to warrant a compliance audit to determine what happened in this campaign and whether there were additional violations besides just failing to file. But the failure to file is in and of itself reasonable grounds to believe there's a violation of the act. So my submission, again, in the absence of any other response or information by the candidate or an agent, is that a compliance audit should be ordered so that it can be determined what this campaign spent on, how much they spent, and who donated, and how much.
Thank you, Mr. Weiner. I have one question for you. Other than the article, the Toronto, I believe it's a Toronto Star article from August 2022, which seems to suggest that the candidate had some brochures. Do you have any evidence to show that the candidate had otherwise incurred expenses?
I don't have evidence. No, I don't. I mean, the reality is it was the last day of the period when I was looking into all these candidates and trying to make determinations about whether or not to file applications. And so all I was able to do was sort of run searches, and if the name still exists, try and use the Wayback Archive, things like that. But campaign spending is by its nature ephemeral. You buy signs and literature and things like that you hand out and they get thrown in the garbage. And I wasn't closely involved in the Scarborough race. I haven't closely involved in any of these races. So, all I can do is see sort of what residual information was available on the internet to indicate there was some spending. How much of that spending, I don't know. But again, my submission is, given there's enough information here to indicate there was at least some spending, that's why the compliance audit process exists. A compliance auditor can order the candidate to provide information, and then the committee will know how much spending there was. And, was it someone who spent $10,000 on a campaign, or was it someone who spent $500 on a campaign? And, maybe if it's 500, then okay, don't proceed anymore. If it was 10,000 and it should not just been a financial statement, but an audited financial statement, that's a different situation. But, that's what the audit process is about in my submission.
Thank you. Do members have any questions? Sorry, Mr. D'Souza, can't quite hear you.
No, sorry, no, I don't have any.
No questions. Okay, thank you. All right, at this time, I'm going to make a motion to go into closed session, and if I can ask members to raise their hand to indicate if they are in favor. Thank you. The motion, oh, sorry, I apologize. I did not ask if the candidate is available to provide submissions. So do we have the candidate either on the phone or on video? Antonius Mantis? No. All right. So Madam Clerk has confirmed that the candidate is not present. So at this time then, we will be going into closed session. I'll ask the clerk to temporarily close the meeting to members of the public and to only provide access to members and appropriate staff for the closed session portion of this meeting. In addition, the YouTube live stream will be suspended until the closed session is over. Members, I'd also remind you to arrange your surroundings so that no other person observes any part of the closed session discussion.
Thank you.
Oh, no, in the open session, when we called for a
Okay,
vote.
sure.
And what we've been doing, just read the first paragraph that shows which way we're going. You don't need to read the full
Certainly.
motion. Thanks. All right, thank you. We have completed our closed session deliberations, and I'm now going to turn it over to members of the committee to speak to the application. I believe one of our members will bring forward the motion.
Thank you, Madam Chair. I would like to move a motion for the Compliance Audit Committee to grant the application for a compliance audit of the election campaign finance of Antonius Mantis.
Okay, we're just going to scroll through it quickly, and it will be posted shortly on the public website. And with that, if I could call the vote, please. All those in favor, raise your hand. Thank you, and the motion carries. And that concludes our business for today. And before we adjourn, again, I'd like to extend the committee's gratitude to Mr. Wiener for sort of upholding his civic duty and really bringing forward information to this committee for our consideration. Thank you for your work. And with that, we are adjourned.